is KTN News.
Only 10 minutes. So let's allow that so that they can see that they have the justice that they need.
Thank you.
Okay, thank you.
Thank you. I think it makes sense. We take it from a senior member of the House. Let it be 30 minutes. We will have 4 more minutes donated to Arwa. Arwa, you have your 4 more minutes to continue with the objection. Then from there we hear Donald. After that we hear who? Apollo. Yes. Let's agree on the timing. So you have 9 minutes. Out of that remains 21. 7. No, not 7. 7 divided by 2 is 10, because he still has his 1 minute. So I'm dividing 29 minutes. Time is not running as I talk. All right? So it is how many minutes? He will have 9 or 10. Give you 10, 9 on 10, 10. Apollo, you have 9 minutes and you have 1 minute. Is that okay?
I shall take that, Mr. Chairman.
Thank you very much. So he has his, let's have his 5 minutes to finish, then you have your 10 minutes. Thank you.
Thank you, Mr. Chairman, for your magnanimity. I was at the point where I was talking about the obligation on the part of this committee to ensure that its proceedings meet the constitutional standard of fair trial. Mr. Chairman, the constitutional standard of fair trial requires that this committee gives everybody an opportunity to understand the question, that the complaint that is raised against him, before he can be called upon to defend. Every person accused, Mr. Chairman, must also be given adequate time to present his or her own defense. Third, there is the right to give evidence and the right to challenge evidence. All these, Mr. Chairman, are found in our own constitution. Now, with regards to the right to be given sufficient information to understand the charge, Mr. Chairman, there is a lot of problems that we have noted with the complaints, and I have captured them in my preliminary objection. Mr. Chairman, you cannot call someone to come and defend himself for proceedings that he barely understands. And I've given examples on the part of Mr. Justice Nyang'aya. One complaint that is raised against him by virtually all petitioners is that he was present and he agreed with some proposals made allegedly by Amos Wako and Raphael Tuju. His position is that he was not present in that meeting, and he has requested for guidance for the CCTV footages that would actually prove that he was not there. Now, if he was not there and he agreed, Mr. Chairman, he needs to know what medium did he use to communicate his agreement. Mr. Chairman, this is a critical question that he needs to know before he is asked to defend himself, because he was not there, and the footages which happily Bomas of Kenya has agreed to provide will confirm that. Mr. Chairman, there is the right to be given adequate time to present one's case. This is an issue that is arising even as we are here in this room. Mr. Chairman, in your own standing orders, you are provided in standing order number 230, sub rule 4, that each petition should be heard within a period of 14 days. My client is facing 4 petitions, and according to the standing order, each of them should be heard within 14 days. Mr. Chairman, these standing orders are made by this House, and they are intended to protect the rights of the parties. Now, it is not possible, Mr. Chairman, when the Constitution gives you the obligation to ensure there is fair trial, and then the standing orders gives you the power to give 14 days, then you limit my client to a maximum of 1 hour. remember, Mr. Chairman, his life, his career is on the line. This committee should be seen, Mr. Chairman, not only to be doing what is right, but more importantly, to be upholding the Constitution. Then there is the issue of the right to present evidence. Mr. Chairman, this is a right that is guaranteed under our own Constitution. And you can only present evidence when you know the evidence you are going to meet. None of the petitions, Mr. Chairman, contained any evidence. You are calling us here to come and cross-examine the petitioners. It is expected, and we have litigated with you. You cannot challenge evidence that you don't know. And that is the reason why the Constitution makes it mandatory that you serve me with the evidence you are going to use against me, so that I can prepare with my advocate, so that I can come and cross-examine you. You are calling us to come and cross-examine him. We don't know what he's going to say. I have not prepared with my client on the content of the evidence he's going to give. So the entire process, Mr. Chairman, violates the Constitution. And I do not expect that my good friend would preside over proceedings that do not uphold the Constitution strictly. Mr. Chairman, there is the question of the right to challenge witnesses. And I would want to argue, Mr. Chairman, that the person being challenged here is the author of the document on which all the petitions are anchored. And that is none other than the chairman of IEBC. Every petitioner recites the content of his affidavit. Asking this gentleman here a question regarding what allegations that were made by the chairman of IEBC is futile. I've given you the example of my client who, as a matter of fact, did not attend the meeting which is alleged to have attended.
You're on matters of evidence. Cancel your matters of evidence now.
But allow me just to finish with one point.
All right, I have a minute.
Yes, Mr. Chairman, there is the petition by Geoffrey Langat, which does not require or ask this commission to remove my client. I do not think this committee has the power to entertain that petition under your own standing order number 230, because it is not a petition seeking the removal of a commissioner. It merely requests you to deliberate. And that therefore means that that particular petition is incompetent and ought not to be heard. Thank you, Mr. Chairman.
Thank you very much. I have some lights in front of me. Yellow means you have 2 minutes. When it goes on, I will just give you half of that. Red means you have 1 minute. So once you see that, you know you're being notified not to be speaking after the time lapse. When I put in stop, it's over. Donald, you have 10 minutes.
Chairman, when my client was served with the petitions last week, she gave me copies of the petitions. I immediately wrote to the clerk of the assembly to confirm those petitions. The one by the Republican Liberty Party is 22 pages. The one by Reverend Dumpi is 31 pages. The one by Geoffrey Langat is 5 pages. And the last one by Award Steve Jerry is 6 pages. Those pages are very important, Mr. Chairman. Once the whole House of Parliament or a committee basically constitutes into an impeachment proceedings committee, it becomes a court of law. And the basic principle of law is parties are bound by the pleadings. So the 4 petitioners are bound by the pages I've referred to. Mr. Chairman, in the South African case of the removal of the Speaker Dilile, which has been referred by our court so many times, and also the decision of our constitutional court in which they quash the decision of the JSC. Both decisions of South Africa and our constitutional court arrived at the same basic decision that once you're doing impeachment proceedings, you are bound by basically our laws. And that the High Court and the constitutional courts have a right to supervise what you're doing. In response to Mr. Chairman, in response to those 4 petitions, I filed the POs on all the 4 petitions. And I urge you to refer, when you retire, to all the grounds I've set out in my preliminary objections to the 4 petitions. Just in a summary, Mr. Chairman, the petition by the Republican Liberty Party, it's on behalf of the party, but it's signed by Mr. Just 1 minute, Chairman. The signature of the person is purporting to be the chairman of the party is Zakaria Matayo. But Your Honor, Mr. Chairman, if you look at Section 16 of the Political Parties Act, a political party is a corporate body. There is no way a person purporting to be a chairman can sign a petition. There is no seal of the party. There is no confirmation or evidence that the party is set to pass a resolution for that Mr. Zakaria to file this petition. The other issue which cuts across all the petitions, Mr. Chairman, is the petitioners referred to so many articles of the Constitution and the articles of the IEBC Act, the Leadership and Integrity Act, and the Public Office Ethics Act. Such petitions, Mr. Chairman, are muddled, they're expansive, they're ambiguous, and they're superfluous. As I've said before, again, you're bound by the laws of this country. A respondent needs to be given a case that has clarity, that is specific, that he can be able to answer. There's no way you can answer such petitions which are basically they go from Article 1 to Article 255 of the Constitution. There's no way you can answer such a question. So, you can answer such a petition. The other issue, Mr. Chairman, is none of the petitions is supported by an affidavit. A petition of such nature cannot be a statement. It can't just be a petition. It has to be backed by an affidavit that deposed to every allegation of fact in the petition. None of them is available in all the 4 petitions. Your Honor, impeachment proceedings, are the highest kind of legal proceedings against any individual, because basically it ends someone's career. And you cannot base a petition on statement that is not evidence in an affidavit. Your Honor, Mr. Chairman, there are 3 allegations against my client: serious violation of the Constitution, gross misconduct, and incompetence. There is no evidence whatsoever on those allegations against my client. Your Honor, the other issue is again, as I said, you're bound by our Fair Administrative Act and Chapter 5 of the Constitution. Where again, across the 4 petitions, you can see that they are coming from a political bias. And that's again an ingredient in our legal system. Where a petition is motivated by bias, then it's not sustainable. You can see basically they are coming from the same political side. Finally, Your Honor, I don't want to take it too much. If the clerk was magnanimous enough to send me all the 9 decisions of this parliament from 2013 until now, all the 9 of them, only one actually succeeded, went through, the JSC one. But still the High Court quashed it. So basically the history of this parliament, none of the impeachment proceedings has been concluded. And just to take you back in history, impeachment proceedings began in England in 14th century during the reign of King Richard II. It was basically intention of parliament to rein in the king without annoying the king. But then in 1795, that was the last impeachment in England, and England ended impeachment proceedings. So there are no longer impeachment in England because they realized the futility of impeachment when there are alternative remedies, which Mr. Arrow has argued, against a public official. We took our legal system, our laws from England. England has moved away from impeachment because it's a waste of time, it's a political tool, it's not a legal tool. It was supposed to rein in public officers for being corrupt, for being incompetent, and for treason. And now we have legal systems that are developed that deal with such errant officers. We have the Public Officers Ethics Act, we have the Corruption Act, we have the Penal Code. So basically, again, as such, if you go through my objections, we have alternative remedies, and this parliament should no longer be taking its time in impeachment proceedings. And Mr. Chairman, finally, as the petitions are not based, they are not supported by any affidavit. They are gossip, hearsay, and to paraphrase our Supreme Court, it's hot air, and they should not be allowed. They should not be entertained. They cannot be allowed to bring additional evidence. What they have filed is complete. I urge Mr. Chairman and the committee, when you deliberate, you go through the petition, you strike them out. And finally, Chairman, I was just saying that because we didn't have enough time to argue our case, if we'll be able to submit the case law, because I have so much case law supporting all the issues I've raised in our objection, I can supply the committee with the case law, and then so that when you're deliberating, at least there is supporting law.
Thank you. Thank you. But impeachment still remains part and parcel of our constitution. So it is not illegal.
It's not illegal, but I'm saying even in England, they moved away. It's not, but it's still in the law in England.
We
it's still in the law, but they stopped practicing
it.
it. Yeah,
but it's not, it's still part and parcel of the celebrated constitution.
It is in the law, and
right.
Yeah, in England.
Thank you.
But they don't.
Thank you very much. Thank you. Apollo, you have how many minutes? Yours are
The ones you
now
allocated
done
me.
20.
Yeah.
Or you
No,
you have 9.
Yes, I have 9.
9 minutes.
Yeah, whatever remains, we will give them to
9,
our lead doctor.
9 minutes.
Thank
Let's
you.
start. Thank you.
Thank you, Chairman. First of all, let me first congratulate the members of this committee who are duly elected by IEBC, the commissioners of which we know. So the commissioners who have been brought before this committee are the ones who conducted the elections that elected the members of this committee to Parliament. Chairman, I also want to adopt the submissions made by my learned colleagues with the necessary modifications as it may be to Commissioner Juliana Cherera. Now, Article 250, Sub-Article 9 of the Constitution, that is where the immunity of commissioners are. And it states very well that a member of the commission or a holder of an independent office for anything done in good faith in the performance of the function of that office, they shall not be victimized. And when you retreat, please look at Article 50, Sub-Article 9. And that one is for all the 4 petitions. Now, going straight to each individual petition, some have been, I don't want to be repetitive, but let's start with the first petition by Republican Liberty Party. The petitioner is different from the signatory. The petitioner is Republican Party. Then it is signed by Zakayo Matayo. So there is no petition there. Honorable Chair, let's go to petition number 2 by Reverend Dennis Ndwiga Zumbi. Again here, this petition falls flat on account of Article 250, Sub-Article 9 of the Constitution. Pardon?
Elaborate on that.
Yes, that is the immunity section that you cannot hold against the commissioners who are doing their work and did their work in a fairly and in good faith performed their function. Honorable Chair, the drama starts with the petition by Geoffrey Langat. Now, Geoffrey Langat, which does not pray for any removal first of any of the commissioners, but refers to somebody, one Juliana Cherere. There is no such a person in IEBC called Juliana Cherere. We have Juliana Cherera, not Cherere. So the removal here is not of Juliana Cherera. Here we have Juliana Cherere. Probably by the time they are making their submission, they'll tell us who that person is. And of course, we will not allow any amendment to this petition. There they are. Now, again, Honorable Chair, if you look at the petition by Owur Steve Jerry, again, seeking removal of an unknown person, Juliana Cherere. There are no such officers by that name in IEBC. The sum total of my submission is that there is no petition before this House, maybe before this committee, capable of being investigated. And the last issue that I want to speak about is what my learned colleague, Dr. Arwa, talked about. If at all this committee was to be seized of this petition, there is a very elaborate procedure that should have been followed, including going to PSC, including other forums before finally landing where we are right now. And if at all again this committee was to be seized of this petition, what they have to do first was to lift the immunity in Article 250, Sub-Article 9. As far as we are concerned, such immunity has not been lifted. Your Honorable Chair, I donate the rest of my minutes that are remaining to Dunstan Omari.
Thank you very much, Chair.
You represent Cherera?
Yes.
And he represents
The
Cherera?
three of us, yes.
Yes. It's left 2.
How many more minutes, Chair?
2.
You can indulge us with 1 minute. Others are a minute. Chair.
No problem. Give you 3 minutes.
Thank you very much. Chair, the sum total of the submissions of my colleagues is that procedurally this motion has not met the threshold to be admitted. 2, under the parliamentary standing orders, these petitions are 4. Our client is supposed to have been given at least 14 days for each petition. Cumulatively, that should be 56 days. That has been waived purely because our client, who is the vice chair, is supposed to be handed over power after the retirement by the current commissioner, the chairman of the commission. So we urge this committee not to fall into that political trap, to move so fast and recommend so that a tribunal is set to remove the current vice chair. Every indication looks at that. The legal requirement, the constitutional requirement have been intentionally been flouted to allow the current chair to continue in the absence of the form. May that be taken very seriously, that this country, this commission, this JLAC is holding the country at ransom. The decision of this committee is likely to impact this country in a manner unknown as serious constitutional crisis. The free serving ones are leaving. The 4, there is a political intention to remove them. We are heading to a serious national crisis. May the committee see deeper than what is being put here.
Chair,
Thank you.
Chair,
Allow him so that he can be paid 1 minute.
just let's not
Paid. As we are paid, we represent. Let him put 1
What is he putting? He finishes.
No, he has only 1 word. He has
All right,
instruction.
1 word.
Only 1 word.
All right, so that
Thank you
we
for-
are fair.
thank you
Let's
for
be
indulging
fair
us.
to Apollo.
Thank you.
Apollo, 1 word. Half a minute.
Thank you, Chair. I want to invite the committee
to the Oaths and Statutory Declarations Act, Chapter 15 of the Laws of Kenya. Now, the petitioner that is the Republican Party, Liberty Party, has alluded to evidence which largely is pegged to the chairman of IEBC affidavit that he presented before the Supreme Court. He has not presented evidence by himself of what he knows by himself in regard to the conduct of the vice chair of the IEBC. So, chair and members of the committee, this petition is not available to be accommodated for channeling because the petitioner himself has not alluded, has gone off the provisions of the Oaths and Statutory Declarations Act. That's the point I wanted to make.
Thank you very much. Chitamba. That is the name?
Geshamba.
Geshamba. Thank you very much. Geshamba, we hear you.
Thank you, Mr. Chair.
1 minute.
Yes, indeed. I would wish to first associate myself with the submissions of my colleagues. I would equally wish to highlight to the House on issues of Article 50 on the fair hearing, Section 3 and Section 35 of the Public Officers Ethics Act, and more importantly, Mr. Chair, Article 35 of the Constitution on access to information. It is our contention, Mr. Chair, that Article 35, on account of the petitions that have been presented before this House, has been greatly violated. And as my colleague, Mr. Nyaberi, has indicated, that all the petitions and the allegations before this House are not supported by any evidence. And if there was any evidence, and in line with Article 35, then this House is mandated to call upon the evidence to be supplied by the petitioners. And in conclusion, I will just indicate that perhaps, and on the face of the petitions, these are petitioners who have come out as persons who had their feelings hurt by the alleged actions of the four commissioners. And there is no forum under law that provides for hurt feelings. And definitely not this House. And as per your prayer, Mr. Chairman, and I would quote, that you sought that the deliberations be seen to be fair, just, and right. And we extend that opportunity back to the floor for the objections that have been raised before you to be given the due consideration on account of the lives of the petitioners before you. That is all.
Thank you. Thank you very much. We've heard you. We need to give you some decision in a few minutes. The most important objection that you have raised is on jurisdiction. Because once we resolve that...
A point of order, Mr. Chairman. Would the other counsel for the other parties, petitioners, be given an opportunity to respond before Chair, you take it on?
Which counsel?
For the petitioners. For the petitioners.
Does he wish to do so?
Procedurally,
wish
yes.
to do so,
Mr. Chairman.
Chair, he didn't ask you for it. I thought he was satisfied. But if he wants to say anything, let him say so.
I'll get my time and I'll respond at that particular time to all the issues raised.
Thank you very much. So the issue of the jurisdiction, your response would be, we have jurisdiction. So why don't we go and determine whether we have or we don't?
Yes, there is jurisdiction.
Chairman, on a point of order. Of course, as a matter of procedure, which chair you know I don't want to belabor, Senator Kongo has a right to respond to the issues raised by the respondents. We are here as non-partisan, neutral people. We want to hear what he has to say. Or even if he has nothing to say, we want to record that he had nothing to say when called upon to speak.
All right. He has forfeited, actually. So
thanks, Chair. Thanks, teacher, for your compliments. I just say that I'm going to get my time, and at that appropriate time, I respond to the emerging issues raised.
Thank you very much. Thank you. I think that is sufficient for now. What we do, because more people are in here, it is the members who will move out. I will take them to the boardroom with the council, and in possibly maximum 20 minutes, we'll be back. So parliamentary council, so that they can guide us on everything. So in 20 minutes, maximum 20 minutes, we'll be back, and we shall give you a ruling. And please, from there, whichever way it goes, we must now proceed, or if we have no jurisdiction, we must terminate the proceedings. Thank you.
Jeanette, perhaps you can give me this forum. Perhaps it's important for him to understand that he cannot respond to this issue once we have made a decision on it.
Chair, if that's the case, if that's the case, I'm guided. I stand guided. I didn't know that you were retreating to make a decision on this. Let me just make a few remarks
on the points of law.
On the points of
Please
law.
do not go to evidence, because much of it was on evidence.
Yes, Chair.
Mr. Chair, just for clarity, do we have a right to respond to what he will have said?
Let's hear it first, so that, you know, if you do that, then it is right to respond and what have you. I give you only 5 minutes, sir, to respond, especially on the issue of jurisdiction.
Most surprised, Chair. Chair, when when the first petitioner lodged the petition in Parliament, it was sent to the Speaker, to the Clerk of the National Assembly. And I understand, Chair, that petition was sent for scrutiny to the relevant legal department, which brought to this committee. So on matters jurisdiction, this committee has immense jurisdiction to make determinations whether the petitions presented have a prima facie case, as you collectively highlighted earlier on. Secondly, Mr. Chair, what I respond to is the document and letter sent by Senior Counsel Donald Kipkorir, and they are supported by other councils on the issues of documents of evidence, affidavits to be attached to the petition. I need to refer them to the Petitions Procedural Act, which entails how a petition can find its way to Parliament. In that regard, our petition is in order and we are ready to present it, Mr. Chair. That's all I have to say.
Mr. Chairman, can I just...
Sorry. Honorable Wanda, you are totally out of order. You cannot absolutely participate in these proceedings.
As amici?
No, you can't. I'm sorry, you're not understanding orders. I'm going to
jurisdiction.
refer you. Sorry, you cannot participate. Sorry.
Mr. Chairman, just give me a hearing.
Take your seat, please.
As amici?
I'm sorry, no.
Serious
No,
matters such as...
No, please.
Such as
You're out of order, and if that is, I'm going to revoke your being here. You're out of order completely.
Point of order, Chair.
Sorry. May we say this? Let me say it. We will have endless points of order. Gentlemen, raise whatever issue you have to raise when we go to make our decision.
No, Chair. That one now is the highest dictatorial way of handling a committee. Chair, let me raise this matter. I'm on the floor.
Let's retreat, please.
No, Chair,
Gentlemen,
that retreatment is what I want to speak on. Chair, the issues that have been raised by the lawyers, the preliminary objections that have been raised by the lawyers representing the respondents, Chair, are very, very heavy matters, Chair. They have raised issues. No, I don't need to retreat, because what is done in private can be harmful to the public. Let us do our things in public so that people know, Kenyans know what we are doing. We are representing Kenyans. So, Vice Chair, I cannot do things in private.
Thank you.
So, Chair, these issues are very heavy.
Thank you.
No, I'm going on. Chair, I'm proposing this. We want to digest those issues, analyze them, internalize them, so that we can come back when we are seized of these issues properly.
Thank you.
So, Chair, I stand on my feet to move a motion that we adjourn this committee officially for now, until such a time when now we reconvene. 20 minutes cannot be enough, Chair, to digest issues that have been raised on jurisdiction, issues of fake names and wild chase goose and hot airs. Chair, those things are very heavy.
We may actually need 5 minutes to
and
do
Chair,
that.
we are not listening here to a presidential petition.
We have all the time to analyze things in this committee, Chair.
Thank you very much.
One of the reasons why Parliament loses petitions all the time in court, Chair, is this issue of hurrying up the petition.
Thank you.
We are in a hurry to score politically. This is a political process, and we want to score politically, and we want to appease people that we have done our work. No, Chair. Let us adjourn the committee officially so that we can retreat and agree when to reconvene. That's our position. Actually, on the minority side, we want to consult more with our researchers, our lawyers. Under Standing Order 230, we are allowed to consult experts. We want to go and consult experts on these issues. Some of us are laymen. The other day when we were in the committee,
Honorable Junet, please, you can't go on forever.
Let me finish. The other day when I was in the committee, we did not agree on this timetable, but you used some words. Somebody who's like me, who's not a lawyer, will not understand. Juriscata, jurisdicata. Those things I have to go and consult.
Thank you.
I have to go and consult my lawyer here. That's the position.
Thank you. We have enough representation for Parliament, for advocates. Honorable Farah, I think we are happy. Anything else is going to be raised when we go to the boardroom. We have maximum 20 minutes. All right? So, hold on. It is in agreement. We have agreed.
We can use that the 20 minutes,
20 minutes to decide
that
we are not in agreement. We come and tell them we are not
24 hours or so.
Thank you very much. Let's retreat.
Honorable Chair.
Chairman, a point of order.
Honorable Chair.
Chairman.
Honorable Chair, but it's also good to also remind Honorable Junet that in the timetable he says that we did not agree. He actually did not attend that meeting, and so he did not participate in it, but all the other members attended.
Chair, that's true. Chair, that's not true. I attended the meeting. Chair, I attended the meeting. That's why you brought the issue of juriscata. I need to know what is juriscata.
Council, let's do this. Carry the standing orders and the Constitution, please.